University. He is currently working as examiner of patent and design since last 6.5 years. And he was appointed at this post after achieving third rank at Indian national level exam, which is equivalent to UPSC exam. And he has conducted more than 50 IPR awareness programs in various schools, colleges, academic institutions, etc. We welcome you to Adhikari Y. Patil School of Engineering, Pratik sir. And with that, I hand over the stage to you. Thank you.
Thank you, ma'am. Thank you very much, ma'am, for enlightening the IPR and giving a brief introduction of the today's guest, Mr. Pratik Hendre. Okay, so now, without wasting so much time, I will turn over to our today's guest, Mr. Pratik Hendre. I request to sir to start their session. Pratik sir, hand over to you.
Yeah. First of all, good morning, everyone. Am I audible?
Yes, sir, you are audible.
Okay. My slides are visible?
Yes, sir, it is visible also.
Yeah, it's changing, right? So,
yes, it's changing.
Okay.
Yes, sir, everything is right.
Okay. So, again, good morning, and we are here for the IPR awareness program, that is to make you aware about all IP rights, that is all intellectual property rights, under the heading of NIPAM as a National Intellectual Property Awareness Mission. This mission started by Government of India and Patent Office to make all the youth, all students to aware about intellectual property rights. In this first slide, you can find this is the logo of IP, Intellectual Property India. In this logo, this is a small symbol. That symbol is signifying your brain. Brain is a gift of God. Everyone having their brain capacity, there's intellect levels. So anything coming from your brain, like new concept, new idea, new invention, new story, new poem, anything coming from your brain, that comes as a property, that is intellectual property. You all are aware about other type of property like home, land, flat, car, but the property you are getting by using your brain, that comes as an intellectual property. As per Global Innovation Index of WIPO, that is World Intellectual Property Organization, India is on 46th rank in 2021. Why India is on 46th rank? As per population, India is second largest country. As per area, India is 7th largest country. Till India is not in within first 10 or not even first 20. The main reason is that the lack of awareness about intellectual property rights. People or youth doesn't know what is intellectual property or what is the benefits of the intellectual property rights. That's the reason India is lacking behind other countries. So it is our motto to be in first 10 5 years. So you should get you should file for more and more number of IP rights. You should get IP rights, and that will help for our level in international level. Now, what is creation of minds? Creation of minds means anything new coming from your mind, your new thinking, new different type of thought process that gives you one type of solutions like any symbol, any name, any shape, patterns, any artistic or literary work, any product, process, any invention, or any traditional knowledge. That is by coming from your brain, your mind. That is all comes under creation of minds. And that all creation of minds can give you different intellectual property rights. In this umbrella of IPR, there are 6 to 7 important IP rights we are going to see in this today's webinar. First is patents. For patents is for invention. Second is design. Design is for design, shape, pattern, configuration. Third is copyright. Copyright is for your artistic or artistic work. Trademark is for any symbol, slogan, name, tagline. Semiconductor integrated circuit layout design, that is SICLD. It is for layout design for any internal circuit. And geographical indication. It is a special tag given for products on local geographical origin. So imagination is more important than knowledge. It is said by Albert Einstein. अगर आपके पास कोई इमेजिनेटिव पावर है या आप उसका यूज करेंगे अच्छे से, that will give you more and more knowledge. So if you are thinking about any particular problem, that time you will start with different angle or different thought process. You are going to see both way, because each coin having two sides. So if you are thinking like differently, you are thinking on both sides, then that gives you imaginative power. That gives you innovative ideas or new solution. So if you are thinking about any problem and the final solution, that is the indirectly process of any intellectual property rights. Because invention means solution to a particular problem. If you are able to give solution to a particular problem, that all comes under invention. Now, what is intellectual property rights? Suppose your principal, Syed sir, gave you one project on one particular topic. So once sir has given you topic, your brain starts to think about that topic. If you are aware about that topic little bit, then you will start to think about that topic in both way. Also, you will start to make a small framework about your project topic. After that small framework, this all work is going on your brain. After that small framework, you will start to search available resources. Resources like guidance from your teacher, friends, colleagues, your books, study materials, also internet. So that all comes under resources. And your actual working on that, actual working, that gives you labor efforts. That gives your final project. This is same as intellectual property. So the combination of brain, resources, and available labor cost or labor efforts, that gives you final output, that is similar as intellectual property rights. Now, what is the importance and significance of intellectual property rights? अगर आपके पास कोई intellectual property rights है, आप उसका खुद का rights protect कर सकते हो. Also, you can exclude others to not use that without your permission. Further, you can utilize that IP rights for commercial earning. So this is the importance of your IP rights. How can you utilize these IP rights? Suppose मेरे पास कोई IP rights है, मैं खुद उसका यूज करूंगा, own use. मेरे सिर्फ इंडिविजुअल के लिए, मेरे फैमिली के लिए उसका यूज करूंगा जो IP rights है, बाकी किसी को दूंगा नहीं, own use. Second option is license or assign rights. If you're having IP rights, you can give license or assign rights to person who are interested in that business or subject matter. Third option is franchisee. Example is McDonald's. The owner of McDonald's is not going everywhere and starting his branch. He's just giving franchises to the person who are interested in that business. Another example, Yevleti. The owner of Yevleti, they have made a brand only. They are not going everywhere and starting his own. They are giving franchises. So this is also one type of utilization of your IP rights. Another option is merchandising. Example is Disney. So in this exchange of this all four way, you will earn more and more money. So this is the utilization and commercialization of your IP rights. Now there is a two type of perspective if you are having IP rights with you. First is common person perspective, second is businessman perspective. Common person, after getting any IP rights, they are feeling pride. Yes, I have this IP rights like patent, design, copyright, whatever. Then they are using that for their academics, for getting a good grades, for promotion. They are taking one printout, putting on wall that I have this patent. Also, nowadays, many people sharing on any social media that I have received this IP rights. That's it. This is common person perspective. But businessman thinks differently. Once they received any IP right, they will start to commercialize that product. Once any product become a commercialized, then they will start to think about the making that product as a brand value. Once any product gets a brand value, in exchange of that, they will start to earn more and more money. Out of that earned money, some part they again invest in new research, new IP right, again new commercialization, new brand value, and that process goes on, that cycle goes continuously. And that in return, they are earning more and more money. So if you are having IP rights with you, think like a businessman. It is a more recommended. Our first IP right is patents. As many are from engineering background and especially from civil engineering. Can anyone tell me what is patents? Just unmute yourself. Answer. Anyone? Okay. Patent is a sovereign right given by sovereign authority. In our country, only government of India is the sovereign authority who is going to give these rights to you. This monopoly rights given for the period of 20 years. The term for patent is 20 years. After 20 years, it goes in public domain. Patents is given for invention, which fulfilling criteria, 3 criteria, that is novelty, inventive step, and industrial applicability. Novelty means that invention is completely new, not known to anyone. Inventive step means that invention having added features as compared to the known invention. And industrial applicability means that invention should applicable for mass industry or whole industry. If anyone is making atom bomb, that is not useful for whole industry or mass people. So then it's not fulfilling criteria of industrial applicability. So if your invention is fulfilling 3 criteria, that is novelty, inventive step, and industrial applicability, then only you will get patent rights. Now, if you are getting any patents in India, then that rights are valid in boundary of India only. There is no concept like international patent or global patent. If you want to make a business in India, Europe, Japan, China, or whichever country, you require to file in that all countries separately. These are some of the famous inventions. Nano car. Tata provided opportunity to middle class to get a 4-wheeler car in the budget of 2-wheeler bike only. So this is a good invention. Then hepatitis vaccine, Jaipur food. These both are invented by Indian inventor. This Jaipur food cost in India is around 2,000 rupees. But similar Jaipur food cost in USA is around 7 to 8 lakh rupees. So we are fortunate that in India there are many inventors who are making a new invention and which is helpful for us. These are some of the examples. This is a baby shower cap. First image is baby shower cap. छोटे बच्चों को जब नहलाते at the time of bathing, they get irritated if water goes in their eyes. So inventor used his creative mind. He made a zigzag-like structure on cap, which is fitting on his head, and that's working. Second is wristband projector. You all are aware about cinema hall projector or your auditorium projector, but this wristband projector can project on your palm, wrist, or nearby place. This is a digital era, so almost 70-80% people are using debit cards or credit cards. To do a transaction by using these cards, instead of carrying that bulky machine, there is a small microchip is there in market. You can connect to your phone or the person who is receiving money his phone, and doing that swapping, you can do easily transaction. This is a good invention. Drone system. You are aware that, or you are knowing that drone is useful for photography or videography purposes. But nowadays, Amazon and some other companies started this drone for goods delivery purposes. So this is an example. This is Wright Brothers flying machine. They filed for patent in 1906. This is Graham Bell's speaking telephone. This is Thomas Edison's light bulb. These three was by famous scientists. Now these two are very interesting and useful in nowadays. This is a cord separator. आप सभी को पता है कि जो कंप्यूटर में जो केबल्स होते हैं एक दूसरे में मिक्स हो जाते हैं तो उनको जब सॉर्ट आउट करना बहुत डिफिकल्ट होता है. This cord separator is working or helping us for solving that problem. Then movable, portable, bendable power strip. You can move or bend as per your requirement. That's giving you a solution. Now there are some things which are non-patentable. Method of agriculture, method of horticulture, method of computer programming, method of treatments on humans or animals. Also the plant and different varieties of plants and animals. That's also non-patentable. Business method, that's also non-patentable. Any three bolus things. If anyone is saying that from D.R. Patil Institute to Mumbai, they are reaching within 1 or 2 seconds by special machine, which is practically not possible today. Such three bolus things are non-patentable. This is the first person who received patent in India. His name was George Alfred Depane. He was civil engineer like you. He received patent in 1856. Means India has a very long history for patents. His invention was an efficient pankha pulling machine. Now you will think that for patent it is required to have a scientific knowledge or big research or only big machine only. Then only you can get patent. Such case is not applicable every time. Because next in next picture you can find it is a simple paper clip. We all are using this paper clip nowadays to hold the set of papers. The inventor used his creative mind to hold the set of paper. He made a wire special structure which can hold different or set of paper, and it's working. He received patent in 1919 at the time of First World War. So if you are having scientific knowledge or big research or any big product, that is well and good. But if you have a solution to a particular problem, which can be a small needle to any machine, you can get patents for that. I think you all are knowing him. He is Michael Jackson. This picture is Michael Jackson's. He received patent for his shoes. He made a special shoes which was helping him to make anti-gravity move. You can see in this picture, this is special groove made by him. He was the inventor of his shoes. He received patent in 1993 from USA. So, should think differently and file for more and more number of patents to get your IP rights powerful. Yes? Anyone is saying anything? Any doubt?
Sir, ask you one question.
Yes.
Dear participants, there is one request that we are taking the question answering session at the end of the session. So it's request
If
to
you have
all
any
of you.
question, you can write in chat box or ask me at the end of session. So that will be helpful for all of students.
Yes, exactly. Thank you, sir. We
Now
are taking the question answering session.
Yeah.
Okay.
Now many people are saying that I have this idea or this invention in my mind, so I can work on that. But is that similar concept or similar idea is already patented by someone or not? So in this, if you are having same doubt, at that time you can search on this public databases. Free public databases are there available. First is public search by INPAS, that is Indian Patent Office. WIPO Patent Scope by World Intellectual Property Organization. eSpaceNet by European Patent Database. And fourth is patents.google. not normal Google. It is patents.google. These are the free databases. You can use paid one if you are having requirements. So I'm just giving example of free databases. You can use this database by using keywords. You can try to find out your invention. Is that already patented or already filed by someone or not? Next IP right is trademark. Any sign and symbol which is capable to distinguish the goods and services from one enterprise to another by using this sign or mark that comes the trademark. Can anyone tell me this symbol belongs to which brand? Just unmute yourself and answer.
Okay.
Nike, right? Very good. This one?
Puma,
Yeah, very
Puma.
good. This one?
McD, McDonald's,
Domino's,
Domino's,
Pizza Hut,
Domino's, then
Okay.
this is Air India
This one?
Post, FedEx, this is Blue Dart Courier Service, and India Post belongs to this.
This you?
Unilever, Hindustan Unilever,
Hindustan Unilever, right? Then this one?
Apple.
Okay.
Oral-B,
Nike.
This is Z,
Apple,
Flipkart.
Flipkart.
Blue Dart.
So these all previous symbols, I have purposefully removed name from that symbol or logo.
Tesla.com,
By just seeing that symbol or logo, you are able to identify that product or a trademark, because that is the power of that trademark. So which subject matter comes under this trademark? First is brand name and tagline. Brand name is Nike and tagline is just do it. So that tagline also makes an impact. Coca-Cola, open happiness. That open happiness is a tagline. Coca-Cola is a brand name. So brand name and tagline, this combination also comes under trademark. Certification mark like BS mark, ISO mark, this also part of trademark. Sound mark, the roaring lion of MGM, Britannia, ting ting ting. Just by listening this tone, you are able to identify this tone belongs to this specific brand only. Nowadays, many people using iPhone. So iPhone having their unique ringtone. Old Nokia phones was having that special ringtone. So these all comes under sound mark. Special logos like combination of different colors. This all comes under
Pratik sir, are you there? Okay, I think so. There is some network issue from the guest side. So just wait for 2 to 3 minutes. Okay, sir is in the meeting. So
okay. Can I start?
yes, sir. Yes, sir. No problem.
Okay. So these all things comes under trademarks. So sign or symbol which is capable to distinguish goods and services from one enterprise to another, that comes under trademark. Then how much time you can enjoy the trademark validity? The term for trademark initially required to register for 10 years. After 10 years, you can renew for further indefinite time as per your requirement. In market, you can find deceptively similar trademarks. Many people trying to fool you by keeping similar name as a brand special trademark, like Puma as a Coma, Nike as a Nike. If you are filing for trademark, then you should be aware and vigilant that no one can make deceptively similar. there are many versions available in market. So you should be aware if you are filing for trademark. Now, how can you identify this product is registered one or not? The R mentioned on any product, that means that product having registered trademark, and TM mentioned on any product means they have filed for registration but yet not received final registration. Next IP right is copyright. Copyright is given for these 6-7 sections, that is literary work, musical work, artistic work, cinematographic films, sound recordings, computer program. So in this section, you can file for copyright. How can you identify any product or work is already copyrighted? So see on that mention on circle, that means that product having copyright rights. Copyright is a legal rights given to creator for his literary, artistic, musical, dramatic work. It is a bundle of rights, means it is a moral right and legal right. It is automatic right. अगर कोई सचिन कोई एक स्टोरी लिखता है तो from that time he will get automatically that rights. Exclusive rights given to creator for his original work. Copyright cannot protect an idea. Suppose सोनाली के दिमाग में कोई एक डिजाइन के आइडिया है या पेटेंट के आइडिया है, एक इन्वेंशन स्टोरी के आइडिया है, उसने कैरेक्टर उसके माइंड में बना लिए, एबीसी रहेंगे, पीक्यूआर उसके और पैरामीटर रहेंगे दिमाग में उसके सोनाली के, उसने किसी को बताया नहीं, नोट
Pratik sir. Yes, Pratik sir. Pratik sir, are you there in the meeting? Hello sir.
Yes ma'am.
Your screen is not visible to us. Can you please share it again? Pratik sir. I think so.
rejoin कर हॅलो मॅम झालं.
आता परत रिमूव्ह झाला त्याचा.
रिमूव्ह करते असं 2-3 वेळा झालं. ओके आता दिसतंय ना पीपीटी? ओके चालेल मी कंटिन्यू करतो. So I'm starting again with from this copyright topic. Am I audible?
Yes, sir.
Yeah, okay. So copyright cannot protect an idea. If you have any idea in your mind and you are not disclosing or expressing that, then you will not get any rights. You require to express your idea. Then only
Hello, Pratik sir.
unmute करते. ओके. हो मी पाठवली पीपीटी तुम्हाला WhatsApp. हो आणि मी ऍक्च्युली फोनवरून पण जॉईन होतोय आता. ओके चालेल. Hello ma'am. Am I audible? Hello?
Yes, sir.
Yeah. I have shared my PPT to Vishwajit sir. I'm just continuing with my copyright PPT. So copyright is a bundle of right and automatic right. It is exclusive rights given to creator for his original work. Copyright cannot protect an idea. Copyright is an exclusive legal right granted to creator for his expression of idea. As I mentioned that if you are not expressing your idea, then you will not get any rights. Copyright owner has to these following rights as to reproduce, translate, adapt, perform, distribute, or any public display of his work. This all rights is with owner. Registration of copyright is not mandatory. Can I continue?
Sir, yes, sir, you can continue.
Yes, sir, you can continue.
So copyright registration is not mandatory for legal.
Requested to don't change the settings. I think so few students are changing the settings, so that's why all the participants and the speakers are also getting.
मॅम मीटिंग मध्ये काय चालू आहे? मॅडम रिमूव्ह करते कोणतं. कोण रिमूव्ह करते रे.
हॅलो. ओके ओके ठीक आहे चालेल मी करतो कंटिन्यू. ओके चालेल ओके. So we are on topic of copyright. Registration of copyright is not mandatory, but for legal enforceability, it is more recommended that you should register your work under copyright. I'm just giving some 1-2 examples regarding copyright. 2-3 years back, there was a movie released by starrer Shah Rukh Khan. That name was Fan. One person came and he claimed in court that this movie is based on his book, but he was not able to prove that how that book went to Shah Rukh Khan or the producer or the maker of that film, and that's the way. Due to I think he was not having proper registration, so that's the reason he was not succeed in court. So it is a more recommended that you should register your work under copyright. There was one more case study related to copyright. One wildlife photographer, David Slater, was there. He went in African jungle. He purposefully kept his phone at one place and he left that place. One monkey came, ape, and he took a selfie of himself. Due to his data was backed up by Google Drive, he received that photo, and one magazine published that photo without that David Slater's permission. Now David Slater went to court that saying that the copyright of that photo is with me because this captured by my phone or my device. That magazine was saying that it is not captured by you, so you don't have that rights. Then PETA, that Animal Welfare Association, also came in this picture, in this case, and they also claim that copyright should be given to us, that we can use that money for animals' welfare. Then US court gave a special judgment by considering all facts that animals should not get copyright. Copyright is given to only the person who is the creator, and the rights of that photo or the money earned from that photo, they distributed for the welfare of animals. It was a landmark case related to copyright. These are the sections where we are filing for copyright, like literary work, any newspaper, news article, Any story, poem, joke, all comes, computer program, this also comes under literary work. Paintings, photography, drawings. If anyone is good in photography or painting, they should register their work. So if those who are interested in that painting, they can earn money or get monetary benefits. Then films, music, choreography, this also comes under copyright. Now, what is the term for copyright? If I am the author of any book, then I will enjoy that copyright rights for whole my lifetime, full my lifetime. After my death, my legal will enjoy more 60 years for that rights. So for literary work, the lifetime of author plus 60 years after the death of author. For films, music, this copyright term is 60 years from the date of publication. From which date it is going to publish, from that day, the 60 years is going to start. Next is broadcaster's right. Example, Kapil Sharma show. The broadcasting rights is with Sony TV. So no other competitor can telecast Kapil Sharma show without Sony TV's permission. Similarly, Zee Antakshari, the broadcasting rights is with Zee TV. They can telecast that show n number of time at any number of time without anyone's permission because they're having broadcasters' rights. The term for broadcasters' rights is 25 years. Next is performers' right. Performers like actor, singer, juggler, musician, puppet show. Performers' right is valid for 50 years. Next is geographical indication. Can anyone tell me what is geographical indication? Okay. Most of the people are drinking tea. They are preferring Assam tea or Darjeeling tea. 2 months back, there was a mango season. People was preferring Kokan Alfonso. If you are going in market to buy a or Santri, you are preferring Nagpur oranges. So this was the 3 example. No one is asking for Patil's mango or More's mango. They are asking for Kokan Alfonso, Kokan mango. Because this geographical indication tag received for that products. So geographical indication is a tag given on products which having special qualities due to local environmental condition and local labor skills. Such tag given for that product. Example is Mahabaleshwar strawberry, Puneri pagdi, Sindhudurga Ratnagiri kokum, Chanderi fabric, Tejpur lychee, Madhubani painting, Warli painting, Basmati rice, Kanchipuram silk, Paithani sadi, Alfonso mango, Nagpur orange, Kolhapuri chappal, Kolhapuri jaggery, Bikaneri bhujia, Agra petha, Goa feni. Darjeeling tea is the first registered product under this GI tag. They received this GI tag in 2004. In India, there is more than 300 products which having this special GI tag. Solapur chadar, Solapur terry towel, Puneri pagdi, Nasik grapes, Jalgaon banana, Jalgaon brinjal bahari, Paithani sadi, Banarsi sadi, Mahabaleshwar strawberry, Warli painting, Magai pan from Bihar, this Kolhapuri jaggery, Kolhapuri chappal, oranges from Nagpur, kokum from Sindhudurg Ratnagiri. So these all products having special tag by that local geographical name, not for any person's name. Other famous GI, Lasalgaon onion, Wagya Gevda, Mangalveda jawar, Beed custard apple, Jalgaon banana. So this was related to geographical indication tag. Next IP is Semiconductor Integrated Circuit Layout Design, that is SICLD. This tag given, this IP rights given for the period of 10 years for its new and special design on your chip This is useful in applications like medical devices, IT related technologies, electronic technologies. In this field, this SICLD is useful. Today's our main topic, or we are going to in detail related to design. And next IP is design patent or industrial design. Design is an ornamental or aesthetic aspects of an article. The features like shapes, patterns, configuration, composition of lines, combination of two-dimensional, three-dimensional, or separately. All these design, which is judged solely by your eyes. If you are able to judge any special design by your eyes, then it comes under design patent. The manufacturing process or the manufacturing material, that doesn't make any effect if you are having the special design with you. Initially, you require to file for 10 years. You can more renew for more 5 years. Industrial design is related to features like shape, configuration, patterns, combination of colors, combination of two-dimensional or three-dimensional images. It is applied to an article by industrial process. It should appeal to your eyes. The constructional feature or the constructional process that doesn't include in this design pattern. In market, you can find many mineral water bottles companies are there, but each company trying to make their bottle design as unique as compared to their competitor. Similarly, your phone, your laptop. Simple example, biscuits, Parle-G, Marie, Good Day, each company keeping their shape or design of their biscuits as a different. Many companies are coming with Tetra Pak. So this each company trying to make their Tetra Pak is unique one or different one. Coca-Cola bottle, they have registered this bottle shape under design patent. So no other competitor can make same design as Coca-Cola. That glass also registered under this design patent or industrial design. Then Statue of Liberty and Coca-Cola, these are the famous examples related to design patent. Now if you're having set of products, means same design, same sizes, different products, set is there. For such cases also you can file for set design. Example is crockery set, jewelry set, sofa set, knife set, pen set. So these comes under design patent. Now you can find these all are the pencils. The use is for only pencil purpose, for drawing. But each having the unique design, unique shape. Different shapes, toys, different shapes, ornaments, combination of lines, combination of colors, combination of patterns, different shapes, glasses, this all comes under design patent. Design now related to filing and its act. What is the background about this design? How to file or where to file? We are going to see in this next slides. If a group of article meets the criteria related to design, that it is having unique design or new one, not known to anyone, then you are the design. If you are filing for design and filing for the set of design, if your set of products are not same size, having same design but not same size, that time that's not fulfilling criteria of set design. Because example tea set, in that tea set, all that cup having same size. If the small big sizes cup are kept together, then that's not fulfilling criteria of set design. Now where to file for this design? You can file online or offline mode. Online mode, you can directly visit ipindia.nic.in where you can file the design portal. On that, by going online mode, you can file. There is an offline mode also available. You can visit nearest patent office. In your case, Mumbai Patent Office is the nearest one. Indian Patent Office Delhi, Indian Patent Office Mumbai, Indian Patent Office Chennai, and Indian Patent Office Kolkata. These are the 4 offices in India which can receive your physical file. Then these offices making that your application in digitized mode and sending to Kolkata, because at Kolkata only they having special examiner for these design exam patents. For filing, you require to file DD in favor of controller of design. Then your further examination, registration, publication, and post-registration work, this all will be going to take place at Kolkata. But you can access that all details on online mode or your nearest patent office. Now, what is the actual application fees for individual or small entity? If you are filing as an individual, small entities, a startup, then fees is around 1,000 rupees for application. Or if you are filing as a industry or a big company other than natural person, in that case fees is around 4,000 rupees. There is a form 1.
Hello, Pratik sir. Hello. Am I audible, sir? Okay, I think so. There is a network issue with our chief guest. We will wait for few minutes. Pratik sir will rejoin to us. Pratik sir, you are in the meeting. Yeah. Maybe there is a network issue, sir.
Yeah, maybe.
Yeah.
So
you are visible.
Yeah, okay. You required to provide 2 sets of your design in 7 to 8 angles view. That front view, top view, you are better knowing that all views. So you require to provide that all 7 to 8 sides view. Such a way, 2 sets required to provide. If you are filing as an individual, then power of attorney is not required. But if you are filing by using any agent, then in that cases power of attorney is required by using Form 21. If you are filing as an industry or any company, in that case, assignment of the documents, assigning of rights, that document, that power assignment is required. If you are filing as a startup or as a small entity, in that case, you should prove by providing document that you have already registered under DPIIT as a startup or small scale industry. In design, the perspective view is required to provide. The novelty resides in that shape and configuration of teapot as illustrated. Claim should be, you should not claim for this constructional feature or mechanical action. You should claim only the design. You should not claim like any words, letter, any number or any trademarks appearing on that design. You are required to claim only that special design only. This is the example of any one specimen copy of your this design application. This is the final registration certificate of registration of design is showing where the design number, date, and the sign by the Controller General of Patents and Design. All the registered designs are going to publish in Patents Journal. After registration only your design is going to publish in journal. That registered design in that journal, the best view or only 1 or 2 suitable views only going to represent at the time of publication. This is the example of one published document or public design. This is a design number. This is a class. There are different classes of that special designs. The applicant name, its address, date of registration, and title. Now, how can you find that this product is having registered design or not? The registered REGD or RD, if these three different versions are mentioned with registration number of that design, then only you can find that product is registered design. Now, related to some timeline, if you have filed for registration of design and you have received the first examination report, that is FER, then you have 6 months time to reply that report. If you require more time, then you can extend that by more 3 months, but you require to file that special request before the ending that 6 months. The term for design is 10 years, and you can extend or renew for more 5 years. That is total 15 years only. So if you want to file or get more details about patents, design, trademarks, and geographical indication, you can visit this ipindia.nic.in. Related to copyright, you can visit copyright.gov.in. So in this slide, you can find this is a single product which having multiple IP rights. This is MacBook. LED display is patented one. The body of laptop have registered under design patent. The Apple sign having trademarks. The user manual of this MacBook is registered under copyright, and the internal layout design is registered under SICLD, that is semiconductor. Multiple IP rights, and that's the reason they are enjoying monopoly. They are getting more and more earning by that their products. So you should think like commercial purposes or like a businessman to get use or utilize your product in different way or to earn more and more money. So thank you everyone. Thank you DY Patil Association University. Thank you Kadlak sir. Thank you my family Ridan Pranali. Thank you students who have given me opportunity to present or related this IPR topics. Thank you. If anyone having any doubts, you can ask.
Thank you very much, sir, for sharing such valuable knowledge with us. Now I request to participant, if you have any question, then you can unmute yourself and ask the question. Otherwise, you can put one message in the chat box. We can read and you will get the answer of your question. Yes, dear participant, we are allowed from our side to ask, to unmute yourself.
Am I audible?
Yes, ma'am.
Yeah, Pratik sir, I would like to know more about copyright. Actually, can you please tell us different examples for which we can go for copyright?
Can you repeat your question?
Yeah, actually, yes, sir. Actually, I would like to know more about the copyright. So, can you tell us different examples for which we can go in copyright? So, for example, if I'm course in charge of any particular subject in engineering, so some sort of formulae I can prepare or handouts I can prepare, and shall I go? Can I go for it, like copyright filing or something like that?
That formula is made by you, or you are just taking from any references?
Yeah. So I
Because they are going to check that for all
right,
IP rights. That all IP rights, is that fulfilling criteria of novelty, inventive step? If that novel or not, they are going to check. Is that created by you? For other example, if you are filing if you are filing for any story or any book, in that case, or any computer program, so in that case, your data, they will check for initial purposes, is that similar subject matter available or not, and then they will give registration.
Okay.
So
So
if you have
suppose,
new ideas, new topic, already known things, I think they just compilation of data, I don't think they will give that copyright. If you have your own ideas, own story, own joke, anything, any new study material, if you are
right.
making any notes in your own words, then you can go for that.
Okay, okay. So you meant to say like technical papers we are writing, so some
Yes,
sort
yes,
of, है ना? So
yes, yes,
that kind
technical.
of thing we can file for copyright. Okay,
Yeah.
thank you so much. Yeah.
Sir, there is one question in the chat box. That is,
Okay.
what is the difference between copyright and patent?
Patent is given for invention, and copyright is for your artistic work, any story, any poem, any news article, any research paper, any computer program, any music, any film. For such cases, you can get copyright. But for any invention, new technology, for such cases, you can go for patent. For technical or scientific work or scientific invention, you can go for patents.
Okay.
Is this okay?
Thank
More
you, sir.
explanation required?
Okay, sir, there is another one question from the Ashish Bhagat that I want to know what will be the category for my biomedical device for intellectual property registration. It is jaw tracer with the measures movement of lower jaw.
Can you repeat? Biomedical instrument registered for?
Biomedical device for intellectual property registration.
Okay.
It is jaw tracer with measures moment of jaw, lower jaw.
If that is biomedical device, then it goes in patent only. If you are filing for that device, then go for patent. If you want to get that research paper, then you have only research paper and not any prototype or demo of that device. Then you can go for copyright for such research work. Okay, Ashish?
Okay,
That
sir.
next question, patent filing fees, right?
Yes, sir.
So for patent filing, if you are filing as an individual or ordinary person, so in that case, for patent filing fees for individual is around 5,600, and if you are filing as other than natural, that is any company, then it's around 28,000. But this 5,600 fees is around by considering 10 claims and 30 pages only. If your claim is going above more than 10 and pages are going more than 30, then fees may change. But around 5,600 is fees for natural person, any small entity, startup, or any educational institute. What is the advantage of copyright and patent? Both having their own different advantage. These are both different terms and very big, broad terms. So actually, you should understand this IP rights. Then this question will not raise. Patent is for any invention or any technical terms, because 10 or 15 years back we were using that keypad phone. Nowadays all are using smartphone. Technology changing, and inventor or the applicant, they are enjoying that patent rights, or getting monopoly, or they getting more and more money by using that patent. For copyright, you can register your work under copyright. So if anyone wants to use that, they will give you money or any other sort of compensation in that case. So these are two different terms. How to check patent is filed or not? As I have mentioned in that second last slide that related to all websites, visit ipindia.nic.in, where you can check on public search that your subject matter or your application number. By entering that details, you will get the status of your invention, means it is in examination or in hearing process or in first examination report or final grant or reject, whatever status they will show you. What about unique dance moves? You can register under copyright for that. For Rangoli and Mehndi design, if you are unique one and already not known, you have owned the you have the person who have created or designed that, then you can go for design patent for that. These are the sites where you can get more details of the filing procedure or where to file. That is the last question. Can you display the slide with website details? ipindia.nic.in, copyright.gov.in. And if you want any more detailed program regarding this, you can visit this RGNIPM. It is our training center at Nagpur. You can contact them or for their further more detailed program on any particular subject matter like patents, design, trademark, or copyright.
Thank you very much, sir. I think so. All participants get their questions answer, and they are satisfied with the answer also, right? So thank you once again, and thank you very much, sir, for sharing such a valuable knowledge with us and with our students as well as faculties. Uh, Now I request to Kadlak sir to give a vote of thanks. Before that, there is one request to all the participants that I have shared the link of feedback form in the chat box. So please sincerely fill that chat box. Then and then you will receive the certificate of the webinar. Thank you very much. Thank you. Vishwajit sir, hand over to you.
Thank you, ma'am. Good afternoon to our honorable chief guest, Mr. Pratik Hendre sir, the management committee, teachers, my dear students, and everyone gathered here. It's my privilege to propose a vote of thanks and acknowledge the contribution of those who worked really hard to make this event possible. I, Vishwajit Kadlak, on behalf of Ajinkya D.Y. Patil School of Engineering, extend my sincere thanks to the Almighty for making today's event grand success. I extend a hearty vote of thanks to our chief guest, Mr. Pratik Hendre sir, who spared time from his busy schedule to grace the occasion. Today we had an opportunity to hear your thoughts, and this will surely encourage us in all our future endeavors. A special mention to our respected management, Dr. Kamaljit Kaur Madam, Director Technical Campus, Principal Dr. F.B. Sayyed Sir, for giving us an opportunity to arrange and such events. Finally, I thanks to all head of the department and committee members and faculties and their students to make this event successful. Thank you all. Have a great day. Thank you, sir.
Thank you, sir.
Thank you, sir. So with the permission of our director ma'am and our HOD sir, principal sir, we will conclude the session. Thank you very much. I requested to all the participants, you can leave the meeting.
Before leaving the meeting, please ensure that you have filled the feedback form, because accordingly you will get the participation certificate. So please first and then leave the meeting. Thank you all.